All right, if everybody's ready, I think I'll go ahead and start. First off, I'd like to say good evening, everyone, and thanks for coming by and tuning in. We appreciate you guys showing up. My name is Taylor Rivera, and my colleagues and I are student attorneys at the Entrepreneurship Clinic with the University of Nebraska of Law. The Entrepreneurship Clinic is an educational program that serves the dual purposes of providing students with a valuable educational experience and providing free legal services to individuals and organizations across the state of Nebraska. Our time in the clinic has given us opportunity to work with real clients on a variety of real issues, including trademarks, corporate restructuring, and entity selection and formation. We encourage all of you to check more out about the clinic on the UNL website, and if you feel so inclined, apply to the program. Tonight, my colleagues and I are going to be discussing different kinds of business structures that people use to mitigate some of the common legal and tax liabilities associated with their business ventures. To start, I will be discussing what I call the non-filed entities, how they operate, and generally what kind of risks they pose to their owners. And then after that, Marcus is going to talk to you guys about the kinds of entities that require some kind of filing and generally why it's worth the effort to go ahead and go through with such a filing. And last, hopefully, we'll have our colleague Shailana up here to discuss some of the tax benefits and implications of certain kinds of business structures. And there will be a Q&A after our presentation tonight. And because each of us has a very limited amount of time to discuss some really complex concepts with you guys, we encourage you to write down any questions and save them for that Q&A afterward. And with that said, I'd like to start by telling you why tonight's presentation is important to you all. We all know that business can be risky. You can be sued, creditors can come after you, and you can go under fairly easily. Tonight, my colleagues and I are here to make you aware of some of those risks, and more importantly, discuss with you how you as a business owner can start to best cover your assets. And with that, I'll start my talk on the non-filed entities. So each kind of business structure has its own advantages and disadvantages when it comes to operating structure, registration and filing costs, legal liabilities, and taxation. So this will sort of be the lens through which we analyze a lot of these business organizations tonight. So to start, what is a sole proprietorship? A sole proprietorship, simply put, is just a business owned by a single person. No filings required, it's pretty quick and easy. The operating structure is that the owner tends to make all of the business decisions for the business. They also have to arrange any of the capital needs for their business on their own, and they're also going to bear any of those losses and profits on their own. And an important thing to take note of with sole proprietorships is that there is no legal distinction between an owner and the business. It's very important when it comes to how creditors get their obligations filled and when it comes to any kind of lawsuits. So, as I said earlier, sole proprietorships don't require any kind of filings to establish. However, you will usually be required as a business to file a fictitious business name or a trade name. You'll also see that as a DBA. And depending on the nature of what you're doing, you may also be required to file for certain licenses or permits. Now, a huge area of law that I know that hits upon sole proprietorships that a lot of people kind of gloss over is agency law. And this really comes into the picture whenever you as a business owner think about hiring employees. Anytime an employee-employer relationship is formed, that's going to form what's called a fiduciary relationship. And fiduciary, simply put, just means that you have to put someone else's interests above your own, whomever you are a fiduciary to. So what that means in the context of a sole proprietorship is that an agent or employee has to act in the best interest of their employer. And they're also going to be personally liable for any actions that are negligent or reckless and cause harm to their employer or their business. And another key aspect about the fiduciary relationship with just an employee-employer, an employee has to act within the scope of authority given to them by an employer. If they ever go outside of that authority given to them by their employers, they're going to be liable to that employer. But a key thing is that employees can be a huge potential source of legal disputes with what's called vicarious liability, which I'll break down a little bit more as we go. So what are some of the advantages of operating as a sole proprietorship? As I said earlier, there's no filings. One person makes all the decisions, so it's simple. The simplest operating structure you can go with. These tend to be good for operating in areas where the likelihood of being sued is going to be minimal, and the owner isn't going to owe any fiduciary duties to the business or anyone else. That can't be said for their employees. Obviously, their employees are going to have to look out for the best interests of their employers. So, because this is quick and easy, sole proprietorships have become the most prevalent form of small business in the U.S. today. But this exposes the owners to what's called unlimited liability for any of the actions and losses of the business. Simply put, this just means that all of the owner's personal assets are at risk because there is no legal distinction between the business and the owner. The owner is going to be liable for anything the business would be liable for, and vice versa. So what are some of the disadvantages? Let's break down this unlimited liability a little bit more. Unlimited liability means that the owner is going to be personally liable for all the business's debts and obligations, so any contracts or loans you get in the capacity of your business, you're going to be liable for as well as the owner. The owners are also going to be personally liable for any lawsuits that result from any of the actions taken on or behalf of the business, because again, there is no legal distinction between the owner and the business. And again, last, the owner can be personally or vicariously liable for the actions of their agents or employees if those actions are committed within the scope of their employment. Now, that phrase, within the scope of their employment, is really the key factor here. And we could spend an hour on this, but I'll just let you know this. That's not a really hard, fast rule. Whether or not something's within the scope of an employee's employment is a rule that's made up of a bunch of factors, and those factors have to be weighed in front of some kind of judicial body, whether it be a judge or a jury. And anytime you're at that point, it's going to be a gamble whether or not things are going to fall your way. So next, I'm going to talk to you about the second non-filed entity, and that's going to be what's called a partnership. Partnerships are essentially just when two people get together and they operate a business together for profit. Now, a key thing, this is the statutory definition you see up here. A key thing to be aware of is that when these two people come together and start doing business together, this forms a partnership in the state of Nebraska, whether or not these persons intended to form one or not. And that will be important later on as you see with the liabilities and some of these rules. So, some of the bodies of law that touch on partnerships are obviously going to be the state statute, the Nebraska Partnership Statute. So, state law is going to touch upon partnerships. Contract law, anytime you have a partnership agreement between the two partners, and again, a little bit of that agency law. So the operating structure of a partnership is that you can establish one via an oral or written agreement, and you don't have to file that agreement with any kind of state entities. Generally, partners agree to just share the losses and profits of the business. They share in the business decisions of the business. And a really important concept to get here is that a partnership in some instances is going to be treated as a separate entity from the partners, and for others it'll be treated as a group of individual partners. So again, with the sole proprietorship, you didn't have any kind of legal distinction between the business owner and the business. Now you have that legal distinction sometimes with a partnership. Another structural thing about partnerships is we talked about fiduciary duties in the context of a sole proprietorship. Well, in a partnership, fiduciary duties are owed to the partnership and the other partners by each partner. And what that means in this context is that they have to act, each individual partner has to act with care, and they have to act with loyalty toward the partners and the business. Because a partnership has more than one person's assets on the line and the business's assets on the line, the state has mandated these kind of duties that you cannot break. So we'll start with the duty of care. The duty of care, as we discussed earlier, means that you can't act in a negligent or reckless manner in the conduct of your business, and the partners also have to refrain from any kind of intentional misconduct or knowing violations of the law, again, because that could come back and hurt the other partner's assets. You have to look out for each other's assets. Now, the duty of loyalty, simply put, is just that each partner has to put the interests of the partnership itself above their own. So to kind of highlight what the duty of loyalty is, I've given you 3 examples of how you can violate the duty of loyalty. And that's when a partner participates in a conflicted interest transaction, when a partner steals partnership opportunities away from the business, or when they start competing with the partnership that they're currently in. And those last 2, stealing partnership opportunities and competing with the partnership, those are fairly self-explanatory, but I will go a little bit deeper into the conflicted interest transactions. So conflicted interest transactions, a conflict of interest can come up in one of 2 ways. In the first way, it's when any of the partners have a personal interest in a transaction between the business and some other third party. So, for example, I'm a partner in a partnership, but I own a subsidiary who builds sheds. The partnership is currently looking for someone to build them a shed, and they've come across my subsidiary company. Once I find out that they're looking at my company for that transaction, I will have to disclose to each of the other partners and have their approval before I can actually participate in that transaction. The reason why that is because if I have my business owner hat on with a subsidiary, normally I'm trying to get as much money out of that transaction for myself as possible. Whereas normally when I sit in my partnership hat, the transactions we try to make with the partnership, I'm trying to get those transactions for less with the partnership. So there's a tension between how much money you're trying to get for yourself and how much money the partnership is going to pay. The second way a conflict of interest comes up is if someone closely related to a partner has a personal interest in these kind of transactions. So in this example, rather than me owning a subsidiary, if my wife owns a subsidiary that builds sheds and the company wants to use that subsidiary, I have to disclose to the partners that this is my wife and we have this conflict of interest, and they'll have to approve it. Again, the tension there is the same. Generally, you want your spouse to get as much money as they can out of any given transaction and less when you're dealing with a partnership. So what are some of the advantages of operating as a partnership? Again, these don't require any kind of filings. You can just sort of fall into one. Partners owe fiduciary duties to each other and the partnership, so anytime they start acting negligently or recklessly, you can come after them. You have a claim for that, so you are protected somewhat. Partners also can customize the business arrangement of the partnership in a written agreement called a partnership agreement. However, we're going to talk next about some of the disadvantages, which you'll see are pretty stark. First off, the default rules sort of give you a lack of freedom on certain things, and even within a partnership agreement, some of the default rules are going to supersede what you can do within that partnership agreement. When it comes to liability, this is really important. Partners are jointly and severally liable for the partnership's debts. And what that means is that any creditor that the partnership owes money, that creditor can come after not only the partnership, but each individual partner. And they can do that. The joint and several part means that they can do it all in one big suit, or they can do it all in separate ones. Go after the business first, take all the assets there. If there's not enough, go after each partner until they get their money back. The second thing is that the partners or the partnership can be held liable for the actions of another partner. So if Marcus and I are partners and he goes out and does something crazy, the business and myself can be held liable for his actions. And so, like I said before, you can form a partnership whether or not you intend to under the state statute. And what this means is that these default rules and these liability rules you can stumble into accidentally. So you may stumble into some compliance standards that you're not in compliance with, that you could be held liable for, and anytime the partners go out and do something, you may very well be liable for it without even knowing it. So let's talk a little bit more about what the default rules are. I made them sound a little bit scary in the last slide, and sometimes they are. But generally, what the default rules are is just in the absence of agreement, here's what the relationship between the partners looks like. So for example, each partner, in the absence of an agreement that says otherwise, is going to take an equal share of the partnership profits and losses. That's really important to know whether or not you are in a partnership with someone when you're working on something, because when you finally start making a profit on it and you don't have any kind of agreement, they may be entitled to half of the profit you get for whatever product you're selling. And another example of a default rule is just that each partner has equal rights in the management of the business. So if that doesn't work for you, if you're a partner who only wants to deal with 20% of the work or 20% of the problems, if you don't have an agreement, this is what the state says. You're both equally responsible for it. So a sort of scary rule with the default rules is that a dissociated partner can bind the partnership on certain on agreements for up to 2 years after they leave the partnership or dissociate. But also in the default rules, this 2-year gap can be limited to 90 days if you file a statement of dissociation with the Secretary of State. So what this really enumerates is that, yes, while some of the default rules can be scary and seem like they work against you, if you know a lot of the default rules, they can work in your favor. Filings can work in your favor. So what do you do if you're not satisfied with the default rules? Well, you can create a partnership agreement. This allows the partners to customize the whole entire business arrangement. They can switch around certain aspects of the fiduciary duties. They can change up the distribution of profits and losses, and they can just change up the distribution of management authority within the partnership. However, I said earlier that some of the default rules are going to supersede even what you can do in the partnership agreement, and I give you some examples here. The partnership agreement, you can't write anything in there that's going to limit the rights of third parties. You can't unreasonably restrict the duty of care, so you can't whittle down the duty for someone to act non-negligently and non-recklessly. And again, you can't eliminate the duty of loyalty, but what you can do is specify certain types of activities or transactions that just don't violate the duty of loyalty. And what that does is you can either change the amount of approval you need for those or not have any approval at all. So you can switch that up to a certain degree. And finally, within the partnership agreement, you're not going to be able to unreasonably restrict the right of access to books and records. Each partner of the partnership is going to be entitled to the right of access of those books and records for the period in which they were partners. And with that, I'm going to hand it over to Marcus.
Thanks, Taylor. So I heard a lot about what you can't do, so I want to talk about something a little bit more fun about all the things that you can do. Taylor talked a lot about forming an entity sort of either by accident or automatically. I'd rather do it on my own terms. I'd rather have control of what I want, and if I'm forming the business, I don't want somebody else to tell me how I want to do it. So why even form an entity? I think a lot of you are here because we don't have to convince you that forming an entity is a good idea, but we still have some things we want to go over. And I want to talk about what I call the 3 Ps of why you should form an entity. The first is you get protection. This is pretty common. A lot of people want to protect their assets. Second is that you have power. You get to, as Taylor stated, you get to control a lot of what you do in your business. And the second one is freedom. You don't have, like 2 P's and an F doesn't really roll off the tongue very well. So that's why it's PH, freedom. But you have freedom to decide a lot of what you want to do, how you want to structure it, how you want to divide your assets, things like that. So as far as the first part goes, the protection of your assets is really important, but also you get to protect your branding. We see Walmart is a big brand. They have slogans, they have marks, they have the name Walmart. They want to protect those. So you can do that by forming an entity just by filing trademarks or copyright protection, things like that, that are really important to do. As I stated earlier, you have personal assets, which ties into bankruptcy. So the fact that your entities are kept separate from your personal assets, during bankruptcy, you have a lot of protection. Your business assets are kept separate. And the trustee of a bankruptcy court will really look only at the business assets when trying to relieve your debts. It protects owners from each other. That's kind of a common problem, at least for LLCs and corporations in general. But for LLCs, disputes between owners is pretty common. It happens a lot. And without an agreement, you don't know how to handle those disputes. So it's really important that we'll talk about that later, go into more detail. As far as the power goes, you can set up your internal checks and balances, whether that's how you want to handle disputes between owners and directors, or owners and members, directors and shareholders. You get a structure in place that you can set up to really protect each other, yourselves from each other, and also govern how your business operates. Particularly in LLCs, you get to control who's in and who's out. Now, this is really, really important in the context of small businesses or family-owned businesses. A lot of the times you want to keep the ownership in the company, especially if it's 50, 60 years down the line. You want to make sure nobody else can own it. And there's a lot of ways you can do that. You can control who's in and who's out. So as Taylor pointed out earlier, you can also determine how you distribute the profits and I guess importantly the losses amongst each other. In the early stages, most small businesses don't make very much money, so you're basically just distributing losses to each other, which is kind of easy. But when you start making a lot of money, if you don't have something in place, it becomes very complicated because then you guys have to negotiate something once there's a lot of money at stake, and you don't want to be in that position later. As far as the freedom, you can, for the most part, pick where you go. You could pick a state. You can file in almost any state that you want to for almost any business entity that you want to. You can pick the entity type. You're not falling into the categories that Taylor put. It's not automatic. You get to select whether you're an LLC or a corporation, or what type of corporation you are, and then the rules that you have for those. For LLCs, you can select whether you're taxed as a partnership or as an S corp. And Shailana will talk more about the tax benefits and the tax treatment of those. And also the management structure. You get to decide how your company will be managed, and what the rights and responsibilities are between everybody, what the management can do, and what the allocation of authority is in your own company. So these are some big picture considerations that I think everybody should consider when they're going through the process of deciding what entity to form. The first one is, well, what are my options? What can I even do? What entity should I pick from? And most people don't know. There are a lot of options you can pick, but which one's best for you? Next is, which state should I choose? This requires looking at what the laws are of the state, which is the last question, is what laws should you even care about? Whether it's state, local, or even international laws, those are things that everybody should consider when going through the process of entity selection. So as far as generally your options, Taylor touched on most of it. As far as partnership goes, you have the limited partnership, the limited liability partnership, and the limited liability limited partnership. These are sort of specialized, I would say. They're not very common for just general startup businesses. A lot of attorneys or law firms use them, or I guess dentists would use them, medical offices. So for the most part, I'm not going to touch too much more on that. Taylor hit a lot of it. Partnership agreement's really important. But other than that, I'll leave that to Taylor. So corporations, there's a big difference between obviously for-profit and nonprofit. In the for-profit area, we have a distinction between what's called an S corporation and a C corporation. Now in the S corp, the first category of, I guess, the distinction is the tax treatment. S corp they're pass-through entities, and C corps are double tax entities. S corps have a limited number of shareholders. C corps have an unlimited number of shareholders. Then there's the public benefit corporation. Now, this is fairly new. It's sort of a way to structure a business that is very conscious. They call it conscious capitalism. You have specific rights and duties, not only to your shareholders, but also to the community that you're trying to serve. So it's another way to form a for-profit business while maintaining a good image in the public sphere. Lastly, there's the nonprofits. Again, I won't touch too much more on that. They're very similar. The only difference is, I suppose, is what you do with the distribution of your assets or your profits. You can't distribute the money that you earn back to the shareholders or the owners of the business. You got to return it into the company and reinvest it. So then there's the hybrid, which is basically they take all the good things from the partnership and all the good things from the corporation and put it into an LLC. The distinction between the types of LLCs is really based on how you manage it. There's the member managed, there's the manager managed, and then there's just, you by yourself. So however you want to do it. The member manages a group, however many are in your group, decide as a group what you want to do with the business. The manager manage, on the other hand, is basically one person or however many managers you decide have a lot of authority to decide what they want to do, the business direction of the company, what to do with profits and losses, and the members of the corporate or of the LLC kind of sit back and just either hopefully enjoy a profit, but they can also get caught up in the losses too. So for the LLC, as I mentioned earlier, you can elect to be taxed either as a partnership or as an S corp, but I'll leave that to our resident tax expert. That is not me. I don't really want to talk too much more about that. So as far as the first, I think you can pick any state that you want to for the most part. So that's my little catchphrase for that. But here are some things that you should definitely consider. There's the favorability of the laws. When you're looking at what state you want to form in, you want to look at how the laws treat the corporation you want to form or the LLC that you want to form, whether it's really favorable to the business or not so favorable. That should really impact your decision moving forward. The familiarity, this is why a lot of lawyers or a lot of investors pick a certain state. That's why Delaware is so popular, because lawyers and investors know the laws of Delaware. So that's something that you should consider too when you're deciding where to go. Lastly, the fees and taxes. Some states might be cheaper as far as your initial filings go. It might be $25 and then you're good to go, but they have higher taxes, higher income taxes, or higher corporate tax. You want to consider those too. So these are the 3 Fs, and they're actually Fs. I didn't change anything, but those are things you should consider moving forward. Now, as far as some of the areas that are actually governed by state law, one of the most important is the formation, the structure, and the general management of the company. For the most part, these are governed by state law. There's the internal relationships, so the rights and duties among the owners, between themselves or the members, the owners and members, how you can distribute the assets, if there's any limits imposed by law, or the financing. So you have investors who give money in exchange for ownership interest in the company, and what their rights are, and contributions made by either members of the company or by shareholders. Those are partly governed by state law. And then your external relationships, so you have the consumer transactions, whether it's sales or warranties, and then financing as far as with banks and creditors. So anyone basically not an investor, but just giving you a loan. And then like land real estate deals, so if you're buying a building to have your business run out of, that will be considered an external relationship that's governed a lot by state law. Things that are governed by federal law, you have stocks and securities, are probably the big one. The Securities and Exchange Act of 1934 is really complex and complicated. It's very detailed, but it covers a lot, especially if you're looking at corporations. That is one of the laws you'll need to know. Then some employment law, a lot of it's governed by the state, but things like hourly wage, it's governed by federal law. Consumer protection laws, like credit laws, those sort of things, are governed by federal law. And we really do have to consider international law in some respects. If you're doing consumer goods, there's a treaty, it's called the CISG, that applies. It has several opt-out provisions, choice of law provisions, that if you're doing any sort of business with an international supplier or manufacturer or even a consumer, you want to consider the rights and obligations of the CISG. Then there's online sales within the EU. So there's the GDPR that applies. That's basically how you protect consumer data, that if somebody buys something on your website and they're located within the EU, there's certain obligations that would apply for how you can keep and hold their data. And then on a related note, not necessarily international law, but international in context, is the effect of, say, policy decisions as far as like tariffs on imports and exports. Those are things that you really want to consider for how they might impact your business. So just to rehash what we've talked a little bit about, there's the 3 Ps that aren't all Ps. There's how much protection, power, and freedom do you want? These are things that you must consider when you're going through your decision-making process. You should really know that you have options when you're creating your entities, but you need to select the best one for you. And that's why we're here. We can help you do those sorts of things, and we can help steer you in the right track to really help you figure out what's best as far as an entity selection. Lastly, we want to make sure that you understand how the law works as well as how it applies to you. So we see a lot of common mistakes of companies, business owners going online and getting just a form from Google and not reading it, signing it, enacting it, and then that's their agreement, but they don't know how it really applies to them. The problem with those things is if you find a form online, especially on Google, it's at most going to be the bare minimum, and it might not even be the right one for your state. So it might not even be enforceable, or it might not do anything that you want, or might really do something that harms you rather than helps you. So in most cases, I would advise not to get a form and maybe come talk to somebody first, at least before making that decision. So know which laws that you should care about. So now, say that you've decided to make a decision, you've selected some entity, you know what you want to do, now what? That's a pretty common question. If you don't do anything, you're a partnership. If you want to do something more, now there's some additional steps you have to take. So there's critical documents that are often left unaddressed, I would say. So for partnerships, Taylor brought it up, there's the partnership agreement. For LLCs, these are really, really important. If you select, say we're in Nebraska, so all of you are in Nebraska. If we decide to incorporate or even form an LLC in Delaware, we would need to file a certificate of authority to transact business in Nebraska, because Nebraska needs to know that we have the authority to do business here. But a lot of people forget to do that, and there are statutory penalties that apply if you don't. But the most important thing for the LLC is the operating agreement. That is, I would say, more often than not forgotten or not addressed properly. And then 2 or 3 years down the line, or even 10 years down the line, a lot of problems come up from not having that. So as far as corporations go, in order to form it, you have to file the articles of incorporation. It's either articles or certificate, depending on where you are. Delaware, certificate. Nebraska, I believe, is still articles. And then the bylaws, those are what govern your corporation, how the corporation acts, how the board makes its decisions, what the shareholders' rights are. Those are usually spelled out in the bylaws. Again, with the certificate, if you're filing or incorporating somewhere else other than the state where you actually reside. And then if you want to form a nonprofit, there's the Form 1023 that you have to fill out. That's after you form the corporation. So that's with the IRS. So here are some common mistakes that at least we see, especially working in the clinic. Some big problems that we see new business owners make. So the first one is, after I file my certificate, I'm done, I can hit the road, I can go work, and that's all, I'm good to go. Well, wrong. That's not true. There's a lot more that you have to do. In fact, don't forget, once you file your entity, you have to at least draft and adopt some governing documents. You have to tell your business how it's going to run. Otherwise, you fall back on these statutory default rules. That's really dangerous because sometimes they don't benefit you, or there's provisions that you can opt out of that you're sort of limiting your decision for why you even form the entity by not forming by not adopting the governing documents, or whether it's bylaws or operating agreements. So these are the ones, to give you a review, these are the governing documents of basically each entity type. So the other thing is that more often we see people miss, or business owners miss, filings. What happens if you miss a yearly or bi-yearly filing is that your business can go inactive, and then you lose the protection of your assets and the business structure if your business isn't even there. So that's one thing that if you don't know how to do that, definitely go talk to either a lawyer, local lawyer, or apply to the clinic, and we can help you out with that. A second common mistake is that once you create your entity, the personal assets, a lot of people believe that the personal assets are always protected no matter what. You form the entity, everything's separate, and that's the end of the story. Well, that's not quite it. But, I know, shocking, I know. But there are things that you can do to protect yourself, so don't sweat. So, that's a little joke, but yeah, trying to be fair. So fair to everyone. So yeah, balance, keeping the balance, So there are some steps you can take. One thing is that basically do everything that you're required to do by law. If you have a filing you're supposed to file it. If you don't know what those are, talk to somebody, and we can get it straightened out for you. But another thing is to separate business assets from personal assets. A common problem is that business owners commingle funds. So you own a business, you think that I need $100, so I'm just gonna use the company credit card and go buy $100 worth of stuff and use it for personal use. That's where things start getting tricky when creditors come looking for stuff from the business. They can then look to your personal assets under those circumstances. So, and then one thing that a lot of business owners do, maybe unknowingly, is that when they're signing a loan agreement, they're going to a bank, they're trying to get some funds, they sign personal guarantees. So if you're say, a manager or an owner of an LLC, and you sign a personal guarantee, you're signing that I, Marcus, and the LLC, we're both going to be liable for this. So if the LLC doesn't pay, I, Marcus, promise to pay that loan. So be wary of that. That's often in the contract of your loan agreement, so be careful with those. So with that, I'm going to turn the topic of tax over to Shailana to handle. She is our resident expert. There you go.
Thanks. So I've been kind of losing my voice for a couple of days now, so if you can't hear me, please raise your hand. I do have my slides printed out, and Taylor has graciously agreed to read them if necessary. So I know taxes are generally no one's favorite subject. They can be kind of scary, so I thought we might start with a little joke. What's a short accountant's favorite client? Anyone? Small business. That's why we're here, right? So, as Taylor and Marcus have indicated, different entities have different taxes. There's two basic tax structures that an entity might have, either pass-through taxation or corporate taxation, which is sometimes called double tax. So the entities that have the pass-through taxation are S corporations, LLCs, partnerships, and sole proprietorships. An LLC can file a form to be taxed like a corporation if they choose. And then partnerships and sole proprietorships, while they do have the pass-through treatment, they're not eligible for all of the benefits that some filed entities with pass-through treatment have. So there is still a tax benefit and reason that filing can be a good thing. Second of all, corporate taxation, it's sometimes called double taxation. I think it's kind of a misnomer. I'd like to convince you that it's not as scary as double taxation makes it sound. And this applies to C corporations. So let's start by talking about corporate taxation, the double tax. So with this, the corporation pays its taxes every year, just like you do. It files annual taxes. The tax rate for corporations is often lower than it is for individuals. And then the double tax kicks in if the corporation issues a dividend to its shareholders. So if that happens, then the shareholders will pay tax at a dividend rate on the money they receive from the corporation. So that double tax only kicks in if there is a dividend issued. So small businesses are generally not going to issue a dividend for the first few years. You're going to reinvest your profits into your business. So that's not something that you really need to worry about right at first. And sometimes larger businesses don't worry about it either, and they just, Berkshire Hathaway is a great example. They never issue dividends. And then that second layer of tax is just permanently avoided. So we kind of have a visual right here of the first layer and then second layer of tax. The other thing with the second layer of tax, never mind. So pass-through taxation, the corporation or business doesn't pay tax here. The tax is rather passed through to the shareholders. So the profits or loss pass through pro rata to the shareholders. This means if you own, for example, 100% of your business, you'll be responsible for 100% of the taxes. If you only own a 20% share, you only have to pay the taxes of 20% of the business. So the LLC or S corporation will file a tax document, but they will not pay any taxes themselves. They'll file a document with the IRS, letting the IRS know how much tax each of their shareholders is responsible for. They'll send their shareholders a form, kind of like the W-2 that you get from your employer each year, with some numbers that you put on your tax returns, and that helps you figure out, you or your accountant or TurboTax figure out how much you need to pay. So the shareholder pays tax on these amounts based on what their normal tax rate is. So people with higher incomes pay taxes at higher rates. So two shareholders who own the same amount of the business might pay slightly different amounts of tax on that, depending on what their other incomes are. So these taxes are paid every year. So even if the shareholders don't get any money out from the business, they're still responsible for tax for any gains that the business has. So sometimes investors don't like this as much, especially investors from out of state, because they don't want to file a tax return in, for example, Nebraska, if they don't live here. There's also a new deduction you might have heard about. It's called a 199A. It's brand new this year. It's a little complicated, so we're going to go into a little bit more depth in a minute. But first, here's just a visual of the differences between the C corporation and the pass-through taxation. So if $100, the same $100 is coming through, depending on which type of entity you have, you might have different amounts that end up in the shareholder or owner's pockets. So with the C corporation, and these numbers are very simplified. I use the top tax rates just to make it simple. There's basically no situation where you wouldn't have some sort of deductions or possibly a lower tax rate. So you're probably not actually paying this high of tax, but it would be a very complicated PowerPoint slide if I put everything up there, and this will just give you kind of a general idea. So the $100, if it's in the C corporation will pay tax at 21%. That's the corporate tax rate. So then they'll have $79. If they choose to distribute that $79, the shareholder will pay tax at the dividend rate, so 22%, and they'll end up with $56.88 in their pocket. And then over here, if they have a pass-through entity, the $100 will pass through the LLC. They won't pay any tax on it. And whether or not they distribute that $100 to their shareholders, the shareholder is still going to be responsible for tax. I use the top tax rate here because that's where we all want to be, right? But probably I'm not in that tax rate. You might also not be in that tax rate. But if you were, you would then pay 37% tax, so $37. If it got distributed, you'd end up with $63 in your pocket. So this makes the double tax look not so good because it's a lower amount. However, if the distribution is not made and the money stays in the company, that 21% rate can be lower than the shareholder rate. So that's $79 instead of $63. So double tax can be like kind of a scary sounding thing, but it can easily be avoided if that's what you choose to do. Okay, so the 199A deduction that I mentioned earlier, this is brand new this year. Kind of disclaimer on that, the IRS has not yet issued any guidance on this. It can be very complicated. If you think that some of these complicated things might apply to your business, I really urge you to talk to an accountant or a tax attorney who can look at your specific situation and let you know how this would apply, just because it's very complex and there's no way it fits in a PowerPoint slide, much less a 15-minute presentation. So the 199A deduction, the amount of the deduction varies based on the shareholder's income. So if your income is below $157,500 or $315,000 if you're filing a joint return, so if you're married, you get, this is where it's simple, it's just a flat 20% of your pass-through income is deducted. So, pretty simple. If you make more than that, good for you, but it gets complicated. So at that point, the deduction slowly phases out or becomes smaller up until you have an income of $207,500 or $415,000. If you're married filing jointly. So at that point, you are no longer able to take the deduction. In the middle, the amount of your deduction will vary. So some factors can limit the amount that your deduction shrinks, so it helps you maximize the deduction. So the amount of W-2 wages paid, if you have a lot of employees in your business, and you're paying out a lot of wages, that will help you maximize your deduction. The type of business, a service business, the obvious examples that they list are doctors and lawyers, but there's other ones in the tax code, and some of we don't know exactly how it would apply. So if you think you might have a service business, that can work against you. And then the amount of real estate owned, if you own a large real estate holding company, you can take that, you can help maximize your deduction. But again, these factors only apply if you're above that $157,500 threshold amount. And then finally, this deduction, as the law is currently written, will only exist for the next 10 years. After that, Congress may choose to keep it around, they might not. It's kind of up in the air, but you should just make sure you're not counting on this existing indefinitely. One final tax thing that everyone should know about is the self-employment tax, which can be a nasty surprise come April 15th. So people who own their own businesses are responsible for a self-employment tax if their net earnings are over $400. This amount is lower if you work at a church, but most people aren't starting their own churches, so I only have the $400 amount up there. So this is a 15.3% tax rate. It covers the Medicare and Social Security taxes that your employer generally pays for you. So some of this amount can be tax deductible for the business, and you can also choose to pay it quarterly so you don't have a giant tax bill at the end of the year. If you are able to take advantage of this 199A deduction, it'll largely counterbalance this self-employment tax, which can be nice, but probably gonna have to pay self-employment tax. Finally, there are some entities that are tax-free, so nonprofits. So to form a 501c3 nonprofit, you have to start by forming your entity. This can be either a corporation or an LLC. And then within 27 months of forming that entity, you have to file a document called a 1023 with the IRS. There's two types of 1023. You can file the 1023 or the 1023 EZ. And then eligibility for the EZ form is dependent on income. For either form, you must have a demonstrable charitable purpose. The IRS has on their website guidelines for what those might be, but for the most part, it's pretty self-explanatory. We all know what charities are. And you have to have that because if you didn't, no one would pay tax. Everyone would file a 1023. So for the 1023, it's a little bit more expensive. It's a long form, but it gives you, the IRS looks at it more in depth and then gives you a concrete answer about whether or not you're eligible for this tax-free status. A lot of foundations and other donors prefer that you do the full 1023 because it's just a lot more concrete. 1023 EZ form is streamlined. You have to have an annual income below $5,000 to be eligible for this form. It's shorter, it's a little bit cheaper, and the IRS kind of just rubber stamps it. However, if your funding ever goes above $5,000, you're gonna have to file the full 1023, so it might be worth your time to just go ahead and file the full document to start with if you think that your nonprofit might ever grow above $5,000. For either of these, you have to follow the IRS guidelines. So those include things like a nonprofit cannot endorse a candidate for political office. The full list is on the IRS website. Otherwise, you risk losing your tax-free status, which can be pretty nasty. You'll have to be liable for back taxes and some fines. You'll be on the IRS's bad side, and no one really wants to be there. 501c3 will still file an annual tax document called a 990 where they report their income even though they don't pay income tax. They'll report the amount of wages paid. Employees of a nonprofit are still liable for income tax even though the business itself is not. And a nonprofit might still be required to pay some other taxes such as sales tax, just depending on the state and the purpose of the nonprofit. So hopefully all of these things helped you kind of answer some questions about what entity might be best for you. If you would like a copy of the PowerPoint slide or to apply to be a client of the Weibling Entrepreneurship Clinic, you can email leannaeclinic@unl.edu. Otherwise, if anyone has any questions for Taylor, Marcus, or myself, we'd be happy to answer them.
I have a question. Earlier, it was mentioned that there's a legal entity called a single member LLC.
Mm-hmm.
So I guess I'm curious as to why would you maybe select that rather than just be a sole proprietor? Is it simply for the liability protection or?
Sure. So I guess I'll take that one. Which one do you guys want?
Where's the microphone?
So Platt Smith, did you guys hear that question?
I do have a question, actually.
Oh.
I've got some rental houses, and it's set up as a sole proprietorship right now. And I don't know if I'm better off changing this over to an LLC to try to get better protection for. I have quite a few personal assets, and I'm just trying to make sense of. Am I better off with an LLC or sole proprietorship and maybe get a big insurance umbrella, or, I guess that's kind of where I'm at.
Sure. So I guess I can take it in part. So as a general rule, when you're trying to decide between a sole proprietorship and an LLC, it's usually always better to go with an LLC. There's a lot that, as far as your case, we would have to really look at we have to look at a lot of things, but as a general matter, it's more often just it's easy to form an LLC, and that kind of goes to the question that was asked here right before you, as why, if you're looking at either a sole proprietorship or an LLC, what's the difference between that and like a single member LLC? The single member would basically is a sole proprietorship, but with a lot more protection. There's a gap between you and your personal assets because the business is a separate entity. You can structure your business in a way that you want. You can still form or adopt an operating agreement. You can add members later. You can basically define the structure of your agreement as you want to, because you would be the only member, or Taylor would be the only member, or however it would be. There'd just be a couple of filings, and then that would be it. Aside from your yearly reports or your biennial reports, but more often than not, I really can't think of a situation in which a sole proprietorship would be more beneficial than an LLC, aside from,
I also want to add that the LLC will be eligible for that 199A tax deduction, which can be pretty substantial, where a sole proprietorship will not.
And so I guess I'll add a little bit of that to that too. And almost any time you're trying to decide between like what I call the non-filed entities, either a sole proprietorship or a partnership, you do have to take into account like whenever you are, whether you're in a single member LLC or a single member corporation, each of those entities with the filings and the costs and yearly filings, not just your startup filings, these are burdensome. It really just depends on what kind of business you're running, what kind of profit margins you're looking at. You have to decide whether or not you really want to try and go look and be in compliance with some of the filings and other laws that apply to these entities, such as LLCs and corporations. But like Marcus said, generally, just as a general rule, the protections from a legal standpoint for your assets and some of the advantages you get with forming an entity that you don't necessarily get as those non-filed entities can weigh in favor of going ahead and making that filing and putting up with some of those burdens. So there are advantages. I mean, not a lot of people will say this, but there are advantages to the non-filed entities. They're easy. You don't have to do very much. But other than that, that's pretty much it. Every time you go out and you transact business as a sole proprietorship or partnership, you run the risk of something going wrong and someone coming after your assets.
He's just trying to make his topic sound better.
Follow-up question.
Yeah.
One of the documents you said you needed for an LLC, I think, was an operating agreement.
That's right.
Do you need that for a single member LLC since you're the only one in it?
Sure. Yeah. So some of the things that come up, even in the single member LLC context, are I guess sort of later. If you do want to add members, it's sort of harder to add. Sort of harder to change the rules if you wanted to. But as far as just your single member LLC, there's default rules that apply to all LLCs that you can change. They're just default rules. So if you don't want them by statute, you could alter them by an agreement. You could add some indemnification provisions. So if you ever get in trouble for something you did on behalf of the company will have to pay for it, so you don't have to pay for it. So there's things that you can add there too, even in the single member context, that it's really important that you have an operating agreement that sort of spells out what happens in these scenarios. So, yeah, great.
We got another question from Platt Smith.
Yep, Platt Smith, go ahead.
Yeah, I have a question on the LLC. If you owe some money on some properties, would the bank have an issue with you putting that property into an LLC?
So that's a really good question. What can happen sometimes in the context of, say, secured loans, you might be prohibited, depending on the terms of your loan, from changing ownership, transferring ownership, or forming an entity in a different state that might trigger some provisions within your agreement. at the very least, what you often have to do is notify the loan provider or any obligation provider if you're moving collateral between states. So if I have a car that's owned by, Woodhouse until I pay it off, and I leave Nebraska and I go to Delaware, I would probably have to tell Woodhouse that, hey, I'm living in Delaware now, the collateral's in Delaware now, so they have to record it in Delaware. They have to record their security obligation in Delaware. So that happens a lot of times in business context too, especially if you're converting an entity from, say, a sole proprietorship in Nebraska to an LLC in Delaware. While your property wouldn't move, or while, some property may not move, the entity maybe will. And that may trigger some obligations. Obviously I can't know if it will be prohibited without looking at the agreement itself, so I can't give an answer. But just in the general context, those terms are often spelled out either in the agreement that you have or the document spelling out your obligations to your creditor. So
that's something you want to talk over with your bank before you did that then?
Oh yeah. Yeah.
Absolutely. Anytime you're dealing with like an institutional loan, institutionalized like loan entity, like Marcus said, it's really important that almost always in those agreements, you are going to be responsible at the very least for telling people that you're moving and moving your assets. And a lot of the times you are strictly prohibited from transferring ownership of that. And even then, if you transfer ownership wrongfully, the creditors can just go right back to whomever you sold that to and seize that asset and then sell it off to pay that debt. And then the person who you sold the asset to that you weren't supposed to he now has a claim against you personally because you violated a warranty that you could actually sell it to them.
Warranty of title.
Warranty of title, yeah. That's really that.
All right, what else we got? We're here.
Yeah, we're here for you guys.
Ask us whatever you want. My favorite team is the Packers. If anybody cares. Any Packer fans out there? Go Brett Favre.
I will say too that when you tie your real estate and stuff like that up into your businesses, so like if a business entity actually owns it, that may have different effects on your capital gains on that piece of property. So for example, if you own a plot of land or some real estate that's worth like $100 million today, and then 5 years from now it's worth $105 million. When you transfer that the real estate over into the entity, that may have different implications as far as like who has to pay that tax and whether or not you can even get a preferable treatment on that asset. So for example, when you try to leave real estate to someone behind in a will or something like that, they don't have to pay all of the gains, so all of the value, the increased value on that asset. Normally whoever sells that asset has to pay taxes on those gains at a certain rate. But if you were to like leave it in a will or something, that person inherits that free and clear of that other tax basis. And I know that at least when you transfer it into entities, that can disrupt that sometimes. So you have to really plan out what kind of real estate you would be transferring into that entity and whether or not you want to free it up later.
So I'll add, I guess, one last thing to that. When you form a new entity, or even if you convert an entity, that doesn't get rid of your contracts or your contractual obligations. So some people might think, oh, I can be clever and I can just create a new business or transfer it over to something else, and poof, all my problems are solved. That doesn't happen, especially if you're doing a conversion. A lot of statutes cover those. Smarter people than I have thought about all of these problems, and they have put it into writing on how to address them. So
That's why the tax code's this big.
yeah, that's why the tax code's very thick. So yeah, just keep that in mind too. While you're not prohibited by law to do it, you may be prohibited by contract to do it. So,
So, I mean, that is kind of interesting. So if you had an apartment building that was worth, that you bought for 100,000, and now it's worth 200,000, and you wanted to transfer it into your LLC, would it transfer at 200 or 100?
so assuming that there was so it was sole proprietorship before, and then now it's an LLC. I actually don't know. What do you think? I'm not the tax guy, so
Our tax gal.
tax gal with no voice.
So it depends somewhat how many people own it and how much stuff is being transferred. Often you can do a tax-free transaction when you put property into a business that you're forming for the first time. So you will give the business, this apartment building, the business will give you X number of stock, and often, but not always, it'll be a tax-free transaction. Neither of you will owe tax because otherwise you would owe tax on the value of the stock that you got, but because you're exchanging something of equivalent value, you will owe tax there. So the business will then have the same, it's called basis, the value that you first bought the property from at. So that will transfer with the property into the business. So this $200,000 value apartment building will still have the value that you bought it at of $100,000. So then if the business turns around and sells it the next day for $200,000, they'll be liable for $100,000 of capital gains tax.
And he had we saw a question earlier from Platt.
Go ahead, Platt Smith. Floor is yours.
Okay, this is a little bit off the beaten path here, but say for instance, I could put these properties into an LLC. Could I put that LLC into a family trust?
So you would want to put the LLC in a family trust, or put the property in a trust?
I mean, kind of put the whole thing in a family trust envelope type deal where, say for instance, something happened to me, then this property would go to family members.
Sure. So
Like
I'm
the shares or the business as a whole?
so I want to make sure I understand. So the business as a whole, not any individual portion of it. So not just like 20% of it, or right. So just basically the whole business. Is that where you're right?
Yeah, so I got some houses that I got paid for, and I got a few houses that I owe money on. And it works out to where I can put these in the LLC. I guess what I'm looking at is, does it make more sense to have a family trust to put this stuff into, or will? And I'm trying to weigh that one out too.
Sure. So I'm not sure exactly how it works. I'm pretty sure you can, but I am not sure how the process would work. So I would recommend talking to an attorney or.
Yeah, you can. Whether or not it's the best for your situation depends on a lot of other factors about other property that you own and who your heirs would be. Can be very complicated. So as Marcus said, it might be best to talk to an estate or tax lawyer about how to best handle that.
I'll just hold the mic. It's okay.
So any what we call encumbrances. So if those houses are collateral as a basis for a loan, that's what would be considered an encumbrance. An encumbrance generally is just anything that muddies title, that makes it to where it's hard to transfer or sell to other people, and any encumbrances that those properties already have when they're owned by the LLC, even if you put them in that trust and transfer them later, those encumbrances, if they're not taken care of, are still going to be there.
Yeah. Okay.
With that, back to you, Jim. All right. Do you have any other questions or anything? I think Plattsmouth, I think you guys are the last group that has any questions. So if you if you have any questions, you could maybe do a rapid fire or whatever you want. I have my energy drink, so I'm good.
You're not taking up anybody else's time, I don't
Yeah.
think.
We're here to serve you. Okay. All right. I think we're all set then. Well, thanks for tuning in. Thanks for coming. Again, if you have any questions or if you want to apply to the clinic, the email is up here on the PowerPoint. I believe we're going to be distributing this PowerPoint. Is that right? Okay, so if anybody wants this PowerPoint, then you can send an email to the email address on your screen, and you can request it, and then we'll get it out to you. So with that, we bid you farewell.
Thank you, guys.
Yeah.